Hello, and welcome to Mayer Brown's webinar on Stress in the Aviation Industry, Latin American Airlines in Chapter 11, a continuing saga. My name is Richard Stock, and I'm a partner in Mayer Brown's Hong Kong office and head of the firm's Aviation Practice Group. Presenting today will be Craig Reimer, Joaquin C de Baca, and Sean Scott. Craig will be speaking on the Avianca DIP financing. Joaquin will be speaking on the LATAM and Aeromexico DIP financings, and Sean will be speaking on the challenge to the credit card receivable securitization in the Avianca proceedings. Before we begin, I'd like to make a few housekeeping announcements. First, when accessing Mayer Brown's webinars via the On24 platform, we suggest avoiding the use of desktop virtualization software, such as Citrix. In our experience, this can lead to quality loss. Secondly, as listed under the FAQ widget on the right side of your screen, today's program is being streamed through your computer, so there is no dial-in number. For the best audio quality, please make sure your computer speakers or headset are turned on and the volume is up so that you can hear the presentation. If you have any questions that are unanswered during the presentation, we invite you to submit them using the Q&A feature on the left side of your screen. We plan to have a Q&A session if we have time, and if not, then we will follow up with you after the webinar has ended. With that said, let's get started. Craig, over to you.
Thank you, Richard, and thank you to everyone who's joining this morning and this evening, depending on where you're dialing in from. So I'm going to spend a little bit of time discussing the recently filed DIP financing in the Avianca bankruptcy case. That is actually in play as we speak. It was filed a couple weeks ago. It's set for hearing on October 5th. And it actually had yesterday deadline for objections to it. And interestingly, I'm not aware of any objections having been filed to it, which is perhaps one of the benefits of taking 4 to 5 months to get DIP financing lined up in a Chapter 11 case. A lot of the issues that would be fronted at the inception of a case over what sort of form the DIP should take have, I think, been worked out to a large extent with the DIP that's been proposed. Let me run through some of the key features and quirks of this financing package that they've put out there. The financing contemplates providing in total about $1.2 billion in new liquidity, as well as a roll-up of around $722 million of pre-petition debt. The facility would be split between a Tranche A and Tranche B, both covered by the same pool of collateral, with the junior tranche subordinated to the payment in full of Tranche A. Tranche A would be for around $1.3 billion and Tranche B for $722 million. The Tranche A loans would be used in part to acquire the remaining 30% ownership of the loyalty program for Avianca, Life Miles, for around $187.5 million, which has been presented in the DIP motion as being at a significant discount to value, and therefore enabling the airline to acquire additional collateral that it can use to help facilitate its eventual reorganization and provide, again, the liquidity that this DIP ultimately injects into the airline. The new money would also, as part of Tranche A, be used to convert existing note holder claims into DIP loans, and as part of this, the Tranche B facility that's contemplated would roll up the existing stakeholder facility loans that were provided by United, Kingsland Holdings, Cova Capital, and Citadel Advisors into the DIP facility. And in getting this DIP lined up, they've offered up some of the more expensive financing costs for a DIP facility, but again, for an airline that's had as much trouble as Avianca has through different trips through bankruptcy and in its own pending case now, maybe the financing costs are not as unreasonable as one might expect. But as it is, the tranche A would be priced at about LIBOR plus 10.5%, and the tranche B would be at 14.5%. Both of those are payable either in cash or through PIK. The milestones that are articulated in the DIP financing include that a plan of reorganization would be filed by no later than August 10th of 2021. So that's, I think, indicative of how long they think it may take for the airline to return to some level of operational success that could provide an exit for the airline. Embedded within the DIP documents is contemplation that they would have achieved 70% of capacity compared to 2019 levels within the coming 12 months. And again, for a company that's already been in bankruptcy 5 months, to be looking to be in bankruptcy for another year just presents or indicates just how challenging reorganization in the midst of a global pandemic is for this airline and of course for the other airlines that we'll be talking about today. Spending a little more time, I wanted to touch a little bit more on the LifeMiles stock acquisition. That can be acquired under the DIP through a couple of different options that are structured there. One option would be to pay cash of $26.5 million and provide $168.5 million of tranche A1 loans, or alternatively $7.5 million in cash or $187 million of tranche A loans. And the call option to acquire it would be exercisable from the closing on the DIP to September 1st of 2022. The facility also contemplates an exit conversion, which I think is a key aspect to putting Avianca on a path towards a possible successful plan process here. It would enable the airline to convert the tranche B facility into new equity in a reorganized entity. The one interesting feature too of this DIP financing is that they were able to pull it together and present it, even though they've so far run into hurdles in seeking government funding, which when they originally filed was going to be a key aspect of their case. They were looking to obtain up to $370 million of financing from the Colombian government, but the administrative court in Colombia issued an injunction blocking that funding. Avianca has appealed that, but they've nonetheless been able to go forward with the financing that they've lined up for this DIP. So that provides an initial overview of the Avianca funding for this proposed DIP, and I want to turn it over now to my colleague Joaquin, who's going to talk about the DIP financing in a couple of the other pending airline cases.
Yeah, thanks very much, Craig. Of course, this presentation is something of a continuation of our prior Stress in the Aviation Industry presentation, where we discussed some of the backgrounds to all three of these airline cases and some of the fundamentals underlying Chapter 11 for all three of these airlines. And in that presentation, we discussed the LATAM DIP. At that time, there was a significant amount of litigation taking place over the DIP. The primary challenge to that DIP was in respect of its tranche C financing, which included an equity conversion option, which parties were arguing essentially amounted to a sub rosa plan. And it turns out, since we have last been presenting on this, that on September 10th, the bankruptcy court rejected that proposed DIP financing, and it ruled that tranche C was in fact sub rosa or contained sub rosa treatment of those lenders. That equity conversion option / election, basically by dictating future plan terms and impinging on creditors' rights, did in fact amount to sub rosa treatment. The court also noted that that particular feature was not market tested, and LATAM would have had discretion to make that election without court approval. It didn't like either of those features. It noted that it prematurely allocated reorganization value to existing equity, and as such, that entire dip was denied. However, on September 17th, the debtors filed a motion to approve a revised dip, which basically removed that impermissible equity conversion option. It also expanded the lender participation in that tranche. And on September 18th, the bankruptcy court approved that revised financing, noting that the changes basically addressed its prior objections to the dip. That new tranche A is going to be $1.3 billion, as you can see on our slide here. The new tranche C is going to be $1.15. It now includes a $250 million source of funding from Knighthead. And of course, bonds traded up on this news, LATAM's bonds, so the market reacted fairly well to the finalization of what is apparently an important chapter in LATAM's financing. And I should note here also, because this is a continuation of our first presentation, if you have any questions on what we discussed in that prior presentation, we'd be more than happy to address them here, or any of those fundamental type questions. Moving on to Aeromexico's financing. Aeromexico has a proposed $1 billion dip, which includes, there again, an equity election conversion feature. That facility is fully underwritten by Apollo, comprised of a secured tranche 1 in the amount of $200 million and a secured tranche 2 in the amount of $800 million. That tranche 2 is the tranche that contains the equity conversion feature. Interestingly, on August 19th, prior to the LATAM dip decision, Judge Chapman approved that dip financing on an interim basis. There were some limited objections to that, but Judge Chapman nonetheless approved that interim financing, noting at the time that the equity conversion feature was interesting. There again, that was issued before the LATAM ruling, and there was commentary at the time that this may in fact help with exit financing, which could in fact end up being a plus. That final hearing, however, has been adjourned basically indefinitely. Well, I shouldn't say indefinitely. The court has said that the earliest availability would be today, as a matter of fact, September 29th. To hear that, counsel has noted that they're still working through the details, unsurprisingly here, of the equity conversion provisions. So it will be interesting to see how that plays out in light of what has happened in LATAM as well. And with that, I will turn it over to Sean.
Thanks, Joaquin and Craig. There obviously are a lot of interesting dip financing structures that are coming out of these international airline bankruptcies. I'm going to talk now about another issue of note that has arisen in the Avianca bankruptcy, and it relates to Avianca's pre-petition credit card receivable securitization, which is illustrated in the diagram on page 7 of our presentation materials. Prior to filing for bankruptcy, Avianca had entered into a so-called future flow securitization, under which it had sold all future receivables for ticket sales under certain credit card processing agreements to a special purpose vehicle called USAV Flow Limited. The initial purchase price, as the illustration shows, was $150 million. The SPV raised financing to finance that initial purchase price for the receivables, and in essence, any amounts above the monthly debt service would be remitted back to Avianca as additional purchase price. This transaction was done under Colombian law, and it was structured to be a true sale for a variety of reasons. One of the primary purposes for structuring that transaction was to ensure that in any bankruptcy or insolvency of Avianca, that the sale of those future ticket sales, those credit card receivables, would be respected, and that the lenders to the SPV would have recourse to the cash flows without becoming ensnared in the proceeding. Now, the reason for structuring that is probably fairly obvious. You want to ring fence the collections because the debtor, in this case Avianca, received a $150 million upfront payment for a future stream of receivables. As a result, if Avianca were to become bankrupt or insolvent, the concern of the lenders is that the debtor would have a strong incentive to try to disrupt the transaction, to try to claim that the receivables are part of the bankruptcy estate, and to, in effect, get the benefit of those future ticket sales for the bankruptcy estate and for other creditors. And this is precisely what happened here. First, Avianca filed an adversary proceeding seeking to recharacterize the transaction as a disguised financing rather than a true sale. If Avianca were successful in its recharacterization attempt, this could have two consequences. First, the proceeds of all ticket sales would become property of the bankruptcy estate. They could be used by Avianca, subject to certain provisions of the bankruptcy code, rather than being outside the estate. So even if the lenders retained a security interest under it, if it were recharacterized as disguised financing, that cash collateral could potentially be used to fund Avianca's bankruptcy or to fund other aspects of the bankruptcy case. Secondly, the lender's security interest, if it were deemed a disguised financing, would not apply to sales of tickets after the petition date. Instead, Section 552 of the Bankruptcy Code would potentially cut off any security interest on post-petition ticket sales. Now, the adversary proceeding itself is similar to a typical full-blown lawsuit under federal law. So there are complexities in prevailing in a recharacterization action. It includes a complaint, discovery, potential for summary judgment and trial, and also recharacterization actions in bankruptcy court are difficult to prevail upon. So Avianca also took a different tack. They filed a motion seeking to reject certain of the agreements relating to the USAV flow transaction as executory contracts. Under the Bankruptcy Code, an executory contract is a contract under which both parties, the debtor and the non-debtor party, have material unperformed obligation. Here, Avianca sought to reject 8 of its agreements relating to the credit card receivable securitization as executory contracts. Where there is an executory contract, a debtor, in choosing to assume or reject the contract, is given certain benefits. In particular, if a debtor rejects a contract, it is able to be moved from under any future unperformed obligations. Recently, the Supreme Court, in a case called cont'd, held that rejection of an executory contract constitutes a breach, but does not terminate or rescind a rejected contract. And in particular, the court explained that a non-breaching party retains its contract rights even under a rejected contract, but it does relieve the debtor of those future unperformed obligations, as I mentioned. So the Avianca court looked at the 8 applicable agreements under the USAV flow transaction and first had to consider whether they should be considered 1 agreement or 8 agreements. The court determined that under Colombian law, which governed the transaction, there was not a concept under which separate documents could be construed as an integrated agreement, and therefore it looked at the 8 agreements separately. The court concluded that 6 of the agreements were not executory. However, the court did allow the debtor to reject 2 of the agreements, including probably the most material agreement, the Receivables Sale and Purchase Agreement, or the RSPA. The court concluded that that agreement was an executory contract because both the debtors and USAV Flow Limited had remaining material obligations. In particular, the debtors had an obligation upon the termination of either of the 2 credit card processing agreements that were underlying the transaction to enter into replacement credit card processing agreements on substantially similar terms within 10 calendar days. The debtors also had the obligation to sell the receivables thereunder under any of those new agreements for no additional consideration. As a result, the court allowed the debtors to reject both the RSPA and the related undertakings agreement. Now, USAV argued that Avianca, in rejecting those agreements, was seeking to retain contract rights that it had already sold and conferred on USAV Flow Limited. Its view was that by allowing the debtor to reject the agreements, the court would be, in effect, creating a rescission of the contract. The court disagreed with this argument. The court noted, importantly, that rejection left intact USAV's right to receive payments arising from receivables on the specified sales processed by Amex and Creditmatic, which were the two credit card processors pursuant to the card processing agreements. However, by virtue of the rejection, the debtors now have the opportunity potentially to enter into new credit card processing agreements. And based on the court's decision, it appears that any receivables generated under such replacement contracts would be property of the bankruptcy estate and would potentially not be subject to claims of USAV Flow Limited or its lenders. Both USAV Flow Limited and the Secured Lender Group have appealed the court's decision. Interestingly, the notice of appeal itself is a bit unusual because it focuses on a number of the issues that USAV Flow Limited and the lenders are not appealing. They highlight good language in the judge's decision around the fact that rejection is not a rescission, that it does not disturb the sale of the receivables under the Amex and the Creditmatic credit card processing agreements. So it remains to be seen what will happen in the appeal going forward. It also remains to be seen whether the debtor here will attempt to enter into new replacement credit card processing agreements, whether with, in this case, Creditmatic and American Express, or with other potential counterparties for credit card processing to try to recapture, for the benefit of the bankruptcy estate, the cash flow from future ticket sales. So,
thank you. Sorry,
Richard, and I just to wrap up there, with respect to the adversary proceeding itself, it's unclear what will happen on the recharacterization action. The debtors suggested that they would dismiss that action if they received a favorable ruling on the rejection motion. They have not to date done that, but it remains a bit uncertain whether they will continue to pursue the recharacterization action, which, as I mentioned, is difficult to prevail upon, or whether, because of the fairly positive result for the debtors in the rejection motion, they will, in fact, dismiss that proceeding as they indicated they might.
Craig, Joaquin, and Sean, thank you all. We have had some questions. Actually, we've had quite a few questions while the presentation's been ongoing. We have about 5 minutes left, so I'd like to start with the first question. And it's a fairly broad one. Given the apparent complexity of these cases, why is Chapter 11 attractive to airlines at all?
Yeah, thanks, Richard. This is Joaquin. Well, and that's a great question, really. I mean, the U.S. Chapter 11 process has a lot of unique features, which I think have proven appealing to these airlines. First and foremost, the courts themselves are specialized insolvency courts, which is not always the case in other jurisdictions throughout the world. The judges are focused on insolvency entirely. Of course, and Chapter 11 case law is really well developed. In addition to that, DIP financing is, I think, it's proven to be, and we're seeing that it's really critical to all of these airlines. These are capital-intensive businesses, and they're experiencing incredible liquidity pressures. So the availability of that financing is I think, a key attraction for Chapter 11. And then, of course, the worldwide application of the U.S. automatic stay is incredibly useful to these businesses as they are looking to figure out how they need to reorganize and what they're going to do with, in many cases, movable collateral. And so, I mean, all of that proves very attractive to these airlines. There are, of course, downsides as well, as you can see from the slide that's on the screen right now. These cases are, only for the exclusivity period. 2 of the 3 of them have been extended. Their schedules have taken a long time to be filed. Their 341 meetings with creditors have been delayed, and claims bar dates are also running a little bit behind. So clearly these are hard cases, and as such, they're probably expensive cases. It can be really hard and complicated to coordinate all of this on a cross-border basis. But yeah, I think those are the basic outlines of that. And if Sean or Craig have anything to add.
If not, then we'll move to the next question, and this relates to the DIP financings. Actually, we have several questions on the DIP financings. The first one is that these DIP financings are large and complicated. What is the driver for that complexity?
Yeah, Joaquin, this is Sean. Maybe I'll lead off there. I think with respect to the airline bankruptcies, and we're also seeing in some of the large financings out of court for the major U.S. airlines, airlines are obviously extremely capital intensive, and there's very little revenue at this point in time. So any of these rescue financings, whether it's the out of court transactions that United and Delta have done with their loyalty programs. I know American just announced a very large financing package outside of bankruptcy. And then the DIP financings in bankruptcy, I think lenders want to have certainty as to what the long-term plan is. There's obviously very large dollars, and I think when you see these equity conversion features and what have been challenged as potential sub rosa plans, really the lenders want to know that there's not only a way into bankruptcy, but there's a way out of bankruptcy. And as a result, in these DIP financings, the complexity is driven by really lender desire to know that before they're investing billions of dollars, literally, that there is a way out for these parties and that they will emerge right-sized and have an ability to operate outside of Chapter 11.
Thanks, Sean. The next question, do we foresee any other airlines utilizing Chapter 11?
Yeah, Richard, it's Sean. I think it's hard to say at this point in time. Certainly for the major U.S. carriers, as I mentioned, it looks like if American Airlines is able to secure a $5.5 billion Treasury loan with potentially $2 billion more, as has been announced, that is substantial near-term liquidity. As I mentioned, both United in its loyalty program transaction that we at Mayor Brown worked on, as well as the Delta SkyMiles transaction, both of those have created very large amounts of liquidity for the major U.S. carriers. I do think for the reasons Joaquin pointed out, that bankruptcy is a potentially good option for over-levered airlines, and I certainly would not be surprised, especially if there is a second or third wave of COVID or continued pressure on airlines in terms of their revenues and how many seats they're selling, that other carriers may end up in Chapter 11.
Thanks, Sean. We have 1 minute left. There are a number of questions that we've not been able to get to. Joaquin, do you think you could speak just very quickly on the differences between the LATAM and the Aeromexico DIP equity conversion features? Now, LATAM is considered to have sub-rosa characteristics, but that hasn't been the case in the Aeromexico DIP. Are there significant differences?
Well, I think it's important to note here that the hearing in the Aeromexico DIP has not taken place yet, so that the jury is still out on whether the court would agree that it has sub rosa characteristics. And in fact, the fact that they are continuing to rework that equity conversion feature would suggest that they're trying to avoid exactly those issues. And it's important to note here that in the context of LATAM, there were other provisions of that DIP financing which tipped it towards becoming sub-rosa, including the fact that the covenants in that DIP, required it required a LATAM-approved plan of reorganization, and Judge Garrity considered that essentially to be a lockup. So, I think what we would guess is that the folks at Aeromexico are taking page from that ruling and finding a way to structure their equity conversion feature in a way that doesn't maybe cause the same concerns, and it could be why we've seen the adjournments that we've seen.
Thanks, Joaquin. Look, we have gone over time, so I think it's time to wrap this up. We do hope the information shared today was useful. Thank you for participating, and have a great day. Thank you all.